Ciarán, and first of all, just thank you all so much for appearing before the committee today and sharing your insights with us. They're invaluable for us to hear as a committee. I particularly welcome Marie Mulholland from West Cork Women Against Violence, who do incredible work in my constituency supporting women and children experiencing violent and abusive situations, as well as counselling services, training and outreach. Women's Aid in Saoirse provides similar life-changing and life-saving services also. I think in this room we're all aware of the sheer terrifying scale of domestic violence in Ireland, and this bill from Deputy O'Reilly and McDonald really respond to the issues and the realities faced by women and children trying to escape violent and coercive situations. I can't overstate, I think, the value of the committee understanding the specific challenges in rural areas and the complexities of things like family farms. And I know from when I very first got elected onto the council, working with West Cork Women Against Violence on issues around access to down to things as basic as that. You used to be able to go to your community welfare office to go and access emergency accommodation, and that changing to Clonakilty, and the profound impact that that has had on women and their families and keeping people in very dangerous situations. And Marie, you raised the need for domestic violence leave to be taken over a staggered period, as those kind of appointment times, court dates, housing office appointments, all of those things don't occur in that kind of convenient, consecutive way. So I'm just wondering, is there a need to include that in the bill, or can you elaborate on the point, if there's anything else you'd like to add to it around the flexibility in taking that leave? And if there's time, Chair, I'm going to come back in with more questions. Great.
Yeah, I mean, on reading the bill, I couldn't tell whether or not it was a staggered leave or it had to be taken en bloc. So if there was clarity on that, that would be helpful. Yeah.
Sorry, Chair. I know I'm not a witness, but yes, the intention is, and that's why it's an amendment to the Organisation of Work and Time Act, so that it will be taken in the normal way, like leave, in the same way that you can take a half day's leave or a quarter day. Everything has to be done in consultation and all of that, but the intention is that, and that's why it is housed within the Organisation of Work and Time Act, because it will operate similar to leave. So it has to operate for people who are on hourly contracts, weekly contracts. Sorry.
No, that's great. There wouldn't be any need to include it in the...
I don't feel there would, but that does not mean that I wouldn't be hostile as to putting it in. I absolutely would if people felt it was necessary. But I think that it's already very much implicitly there in the Organisation of Work and Time, because that's how leave operates in any event, which again is why it's there. So it's not 10 days in a block when you might be busy for 3 of them and not for 7, and all that. So the intention is that you would take it in that way, not to be taking like a half an hour every day, but that you would be able to break it up and take it accordingly in the same way as you can do with other forms of leave that would be in the Organisation of Work and Time Act. That said, I would certainly welcome discussion on an amendment if it was felt that it's necessary. I wouldn't see it as necessary, but that doesn't mean I wouldn't be open to making sure that it was absolutely crystal clear.
Sometimes if it's not spelled out, you'll get
I understand it. Yes.
Yeah.
No, I understand it. Yeah. Thank you.
Thanks, yeah, that makes sense. Just out of interest, in Vodafone, is that the way people can take it? Is it staggered?
Yeah. So for the way it applies in Vodafone practically is that we would apply the 10 days, and it's just there right beside their annual leave, like their normal annual leave, so they can book it in the same way as their annual leave. And that means that if a new date occurs or another event occurs, they can just use it as they see fit and not ask for permission every single time they need to use it.
Excellent.
Yeah.
Related to the matters raised by Marie, for Women's Aid, you highlighted the additional leave to cover exceptional circumstances. So I think it would help us in recommending additional leave if you gave us a sense of the kind of time required and the complexities faced by women and children experiencing domestic violence and abuse. And you also raised a number of points in relation to confidentiality. So I'm wondering if you could just expand on the need for guidance to assist employers when developing policies in dealing with that and related matters.
Sure. Well, with respect to exceptional additional leave, I know that some employers, with respect to sick leave, for example, will include within policies, and it could equally be included in legislation. It would normally be with the word may, so without obligation, and I don't know whether it would become the rock that you die on to put it in as must, but would be that, you know, where exceptional, so you could have somebody who has an immaculate sick leave record, as an example, but then perhaps contracts a very serious illness such as cancer or something like that, and there will be a procedure whereby you could apply for additional leave in exceptional circumstances. The exceptional circumstances we think should be generously broad, but in effect it's because Maria has already quite rightly stated, you know, depending on the situation, it can be a long or a short journey. You know, 10 days over a 12-month rolling period may be sufficient, you know, in order to accommodate somebody. But if particularly they have protracted court proceedings, and, you know, that, as we say, maybe around breaches of orders themselves, but it also, we do have situations where the courts themselves are used, are weaponised almost, and that very often centres around custody and access matters and maintenance matters. It is, you know, and it's like a war of attrition. So if there can be exceptional circumstances made, we think they should be accommodated. I did quite, again, cheekily put in a lot of appendices in my statement, and there is data in there which shows that actually in terms of the uptake, in terms of both New Zealand and Australia in particular, it wasn't huge, you know, so, and again, it's incredibly hard to disclose. If you have 1 in 4 women, not all of those women will be in employment. Not all of them may need recourse to that leave. So, you know, the numbers you're talking about in terms of the hazard or the risk that an employer might face by going that extra mile to actually just put in that with, you know, when you have, this kind of leads to your second question, which is around confidentiality, kind of feel that it is acknowledged and it is very clear in the bill as drafted. And also we do have, of course, data protection obligations on employers. So I would be saying, no matter what, that you almost have a double lock of employers actually already facing legal obligations around confidentiality. We just identified there's a couple of circumstances where there needs to be a little precision. We understand that, you know, where it talks about the need to disclose, that could manifest in a couple of ways. One, it might be where you have a line manager and perhaps a HR person, and they just need to know for the purposes of processing leave, and it's all within that. But you could also have a situation which is, and again I added it as an appendix, and Marie alluded to it as well, a policy is not just around having paid leave, it also can be around flexible working time, it can be around safety planning. You can have, again, you know, there would be more exceptional circumstances where you may have an individual who poses a threat not just to their current or former partner, but also perhaps to other people in the organisation. So perhaps a member of the security staff may need to be notified that a certain person is not to be put on the premises. You may have reception, you know, but, and with that then being bound by confidentiality. So just some explanation of what that might mean to give staff assurance. We have a policy in Women's Aid ourselves, and similarly it's allowed to be taken in ours, but we would be very clear around, you know, in those situations it's around with informed consent of the individual, that nothing is done, nobody is told without them knowing and being consulted about it, and generally speaking it be in the context of health and safety and workplace health and safety, not just for the person who's being subjected to the abuse, but perhaps other individuals around risk management. But I would say again, rare cases, but it's just good to have them covered so that you don't then inadvertently have somebody's, you know, personal details or information shared, or you have the chilling effect that they're not sure how their information will be received and therefore they won't disclose at all.
Just, yeah, if just in relation to say, because of what everybody said in relation to it, for the employer, from the employer's perspective, was your company already have it in place and were very interested and willing to do it. But what sort of guidance or kind of thing do you think would help other employers to make sure they get kind of specifics like that right in order to deal with confidentiality? If you could go back and have had somebody give you certain bits of advice just out of interest, what would have been helpful to know in advance?
There's a very long list, I think, of things that we would, but Women's Aid were an amazing partner in this, so we were able to get a lot of their knowledge to equip us with this. Like, I think one of the most important things is around the, like just as you were saying, Sarah, around the privacy and safety of the individual, and how we access that. We learned from Women's Aid again that you know, one of the kind of core components of a relationship in domestic violence is that the power and control is constantly taken away from the victim. So everything that we wanted to do as an employer was to be putting back that power and control to the individual. So that for us, in really practical terms, that really looks like things like you know, if somebody, and it has happened, where somebody has come to me and said, I have a domestic violence disclosure on my team. And one of the first things that we'll say is, I don't need to know a name. The only person that needs to know a name is the person who is applying the annual leave to the account of that person. And other than that, we can just have conversations about how to support that individual in the best way for them, and making sure that they are in control of everything. You know, there is a huge list around kind of maybe some of the challenges that we've had, and ensuring like that, you know, even our duty of care to our people managers as they go through this training, which is quite, you know, difficult to go through and can be quite emotional in a lot of ways. And it was probably the first time we've ever created training where we have seen that we had to look at the emotional trajectory of the room to make sure that people, by the end of the day, or the half day that we put our people managers through, that they felt really empowered by the end. And actually we did a survey at the end of every training to ask if they felt, how they felt about taking a disclosure of domestic violence at the end, and they said 95% said that they felt moderately to highly confident in taking a disclosure of domestic violence for an employee, which wouldn't have been the case earlier in the day. So there was definitely, though, that kind of forum, you know, was really important to understand as the training went on. There was also kind of the key, I think Julie mentioned this earlier on, around the key role that our senior leaders played. They came to every single one of our senior leaders attended the training and role modelled that they found this incredibly important. And then we also couldn't underestimate what kind of our diversity and inclusion work over the last couple of years has really embedded into the employees, because after one or two sessions of our training with Women's Aid, they really, the buzz of how the quality of the training and how people felt coming out of the training, and how they felt they learned something that they really didn't have before, and that they were going to use it not just in their work lives but in their lives in general. That created a buzz that actually made it incredibly successful, and it still is quoted as one of the things that makes people the most proud for working at Vodafone, which obviously is hugely meaningful, but also you know, that there are other things that come to the fore, such as people letting you know through a people manager that they had a person who are in one of our areas, or one of our business areas, that said that they had left an abusive relationship because we were talking about it and because it was part of the conversation. So it wasn't necessarily, like in that particular situation, that person didn't even access the policy or take the leave. It was just the fact that we were talking about it that gave them the strength they felt to move on. So, you know, there are so many different aspects to this, and key enablers and challenges that we face throughout. One of the things that we've kind of said as a business as well is that we will talk to anybody who is considering it, because there are lots of HR kind of tricky bits to learn about. So we're really open to having conversations, and we've never said no to a conversation with another business or to another HR team who are thinking of implementing this, because we want them to know that it's possible. There are no privacy and kind of concerns, but unlike any other thing, and it is something that is hugely beneficial, like in this area.